Item number?
Yes.
Could I mention a matter, my lord?
Item 111.
111 and 112 of today's list. May your lordships were very kind to me, lord, abrogate the matter. But could it be a bit more upgraded? Because I'll tell you, lordship, the prime land in Calcutta, my lord, we cannot utilize, my lord, because of the injunction, my lord, which is operating in the matter.
100 and
111 and 112.
next week we will upgrade.
Very
Who
right.
will be appearing for the
Lord,
petition?
we have served notice on, my lord, the petitioner that we are going to mention the
And,
matter. I'll serve another notice. I'll serve
They
another.
the council can be informed
Very well.
that it
Very
will be upgraded.
very well. Very well. I'm so grateful.
I mentioned one more matter.
Hmm.
Item number 153 of the monthly list.
Mhm.
Malada, this is a matter, my lord, where issue is whether a particular area which is being used for 50 years as Qabristan by the Muslim community can be converted to be a playground for the Hindu community. That matter went to the civil court.
Ground is not
No,
for
no,
any
this
kind.
has been, I am opposing. I am opposing. This is done, suit
That is
is
correct.
filed. Waqf board is in session of the matter. Report has been given by the Waqf board.
You want
Still, that because of this, I want this matter, we have filed an application. Let it be transgraded there, my lord. Let the issue be tried by the appropriate authority, my lord, who is in session of the matter.
See, item 153 is clubbed along with item 152.
But we have filed an application, CAN 3.
There is no CAN 3.
Yes, CAN 3 is there. CAN 3 of 2000. In the list itself, it is there, I am told. 3 of CAN number 3 of 25.
In the monthly list.
153.
No. Then monthly list.
Monthly list.
In the supplementary list as well. It is not
No, I
there.
think the serial number is wrong. What is the case?
153, my lord. Case is Gopal Choren versus state.
No. Then to-
Monthly list not kill this.
One is different.
Monthly list 153. Let it be relegated to the appropriate court by civil court in session of the matter. Because of this, getting adjournment years together, 2022 onwards.
There can is there.
Yes, CAN 3 is there.
Well, may it be, my lord, at the top any day, my lord, because we want to relegate the matter to the civil court.
No. Next Thursday, probably possible.
Hope থাকবে? Grateful.
With the permission of my Lord Justice Chatterjee, my Lord, I am mentioning to your Lordship that investigates the matter, my Lord, and that contempt matter. My Lord, they have served a notice on 11th March, file an aggravating compliance report, but it is not at all compliant. Again, they have stated mentioned that on probation, but it is not. There is no question of the probation. It should be direct recruitment.
Okay.
That's why today is the date to appear, but our matter unfortunately has not come.
No,
with the
because
matter.
it's the other division bench.
Yes. That's why I'm mentioning.
You
to
give
Lord.
the number, we list it.
Directed me to join within a month, but on probation we cannot because they are delivered.
No, without prejudice, why don't you join? Without prejudice, you join.
Okay.
We'll qualify it when the case is taken up, and we'll examine whether this probation clause is valid or not. Advise your client to join.
So I shall direct my client on.
You write first. You send a legal notice to them. We have mentioned to the court saying that this is not in full compliance, but however, our clients are willing to join without prejudice to the rights in the contempt petition.
I'm grateful.
And then let them join the joining the court. Let them say that. Then we'll take up the contempt.
I'm grateful.
My Lord, may I be?
Sure.
In this month, some ferry ghats.
No. I think it. See, up to item 49. They are all fresh admissions. So let us see how we progress today.
My Lord, may I be permitted to mention, my Lord, that my item number is 151, but the matter involves misappropriation of funds by the Pradhan. And my Lord, I'm just reading the last order that was passed by my Lord, that the district magistrate and the collector Murshidabad is called upon to explain by way of an affidavit as to why the order dated 3rd May 2023 should not be interfered with on the ground that undue lenience has been shown in the matter with regard to the gross irregularities committed by the Pradhan of Shijgram Gram Panchayat under Bharatpur 1 Panchayat Samiti in Murshidabad district. So my lord asked for an affidavit by from the district magistrate. My lord, till now it's almost 1 year. Now it's 2025. My lord, no affidavits,
Alright.
nothing. My lord.
We'll note down. Item 151,
Yes, up to today's daily list.
Babu Mistri.
Babu Mistry, my lord. So any day, my lord, on that to be mentioned or yes. May I hand over the slip, my lord?
Item number 154 of the day's list. It may be heard any day.
All right.
I'm
Please note down 154 also. Yes,
Lord, this is an urgent leave, my lord, your lordship. Remember the OBC matter, your lordship has already assigned in one bench. The new survey has been started, my lord, extreme urgent, my lord. It has already been submitted before the Supreme Court. Supreme Court has not granted any stay order, but new survey has been conducted, my lord. I want to leave to
this is a PIL.
public interest litigation, my lord, for challenging the new survey to be by for OBC.
All right. Leave
Shall-
granted to file. Let us.
My lord, kindly
lord,
file without the certified
my lord,
copy. My lord,
Date of the order.
January 10, my lord, January 10.
January 10 means it's out of time.
my lord, may I?
5 has to be
Section 5,
filed.
I will file. Right now, I'm only filing memo of appeal. Leave may be.
No. You file it along with section 5. Or when did you apply for the certificate copy?
My lord, it is applied on 18/3.
18/3.
Was late because of the.
My lord,
We can tell the department to issue the certificate copy early. You give the
Madam.
case number.
Great.
My lord, may I have lordship's kind leave to mention a motion of 2018.
2018.
My lord, lordship will remember 3 weeks ago, lordship had decided a minority community matter.
Yes.
My lord, this is a bunch of petitions filed, same school, same point, attack from different.
We'll list it one day. Who
Great.
will be appearing for the?
My lord, I gave a notice I would mention on the 18th. He took it. Now, since the bench didn't sit on the 18th, I gave another notice yesterday that was refused, that the client has taken a change. But this is just avoiding.
Doesn't matter. You please, we'll list it
Lordship,
someday next week or
kindly
the week
permit
after.
me, lordship, that last week, lordship delivered a judgment in respect of a tender matter, lordship. We represented the state respondent, lordship authority, but our name
Your name
not
is not
recorded,
appearing.
lordship.
All right. Please print the name.
My lord, may I be permitted to mention one matter, my lord? This is a 2020 matter, my lord. I have mentioned 2 weeks back also, my lord. This is a custodial death. One PIL has been filed, and I, as a brother of the deceased, I made a police inaction, and later on that has been tagged. Now, my lord, since then, due to COVID and other reasons, my lord, that has not been heard.
2020. madam.
2020. Now, my lord, 2 weeks back, my lords gave a direction to press a letter before the OSD. My lord, I have done the same, but the matter is stuck as same as 114 in the upgrade matter. My lord, the matter will become infructuous, my lord, because this is need to investigation and all.
Let us see how we progress today. 114.
114 of the upgrade list.
All right.
Well, the only difficulty is my police inaction is tagged with that, and for that reason, my lord, nothing has been
All
done,
right.
my lord.
We'll note down. We'll try to do something.
my lord, in
Grateful,
that
my lord.
leave, may I write a letter of assignment or your lordship will be taking up?
No, you have to write. Saying
I'll-
that
I-
the connected matter has been
Uh,
assigned, etc.
Great.
Give them along with the case number.
Yeah,
After the
all
notice.
other matters I will write it down and hand it over to you.
Yes, please call.
Item number 70, my lord. I'll praying for upgradation. I've mentioned this earlier, my lord.
Today,
Chair, my lord,
we'll
I'm
see, sir.
challenging, my lord,
Sir, up to 49, we need to finish. Fresh motions we'll finish.
this is fresh, not fresh, my
No,
lord.
yours is not fresh. Up to 49 is fresh.
My lord, may I be allowed to, this is an urgent matter, my lord. I want to mention it. And my lord, the learned trial court have modified the original order for which 500 families are suffering without bread and butter, like without minimal bread and butter. Even the fishers of the fisheries are left without any medicine.
No, it's a group 9 appeal, is it?
No, ma'am, my lord, this is for inclusion in the list under the heading of admission. Group 9.
Group 9. Fresh case.
Yes, my lord.
All right.
Thank you so much.
Fresh.
My lord, can it be fixed on Monday, my lord?
You give the letter. Call. On the point.
May I mention a matter, my lord? This is against the Eastern Coalfield Limited, my lord. We were directed, my lord, to supply some coal to the petitioner, my lord. In the court below, my lord, that the order was such, my lord. Now, my lord, as on today, my lord, there is no such circular, my lord, that we have to give coal directly to the private respondent, my lord.
What happened to your petition?
We file appeal, my lord. 2 appeal, in fact, my lord. We file upon review application, my lord. That was not allowed, my lord. So, my lord, we file appeal challenging that same order, my lord. So 2 appeals pending before your lordship, my lord. Now they have filed
Give the number, let us see.
contempt application. They have filed, my lord, and tomorrow the contempt is coming to.
That.
The court has held that, my lord, unless, my lord, we It is listed unless at least, my lord, the court will not take
You
consider.
give the number, let us see.
My lord, I shall supply the number.
Appellate side, daily list regarding circuit bench at Port Blair, serial number 1.
Yes, sir.
My lord, I appear for the
petitioner.
Lord, before my learned friend, no, my lord, before my learned friend says anything, I have got something to submit. The first day, this matter which is listed today, I did not appear, but the question was raised by the learned advocate for appearing for the Andaman administration about the maintainability of the writ petition, and that was kept open. Kindly see Lordship's order dated
Para 16 of the order.
yes, para 16 and also maintainability the other paragraph. Now the moot question is after this matter, two matters have also been moved by the same petitioner, and the question I am raising before the Lordship, subject to what your Lordship will say, that in the first matter, I find the number 1 respondent is the Secretary Environment Department.
Secretary
Environment Department.
Yes.
Now, in the second writ petition that is moved thereafter, that is also relating to environment. Simplicity relating to environment. Therefore, my lord, this is a project of 72,000 crores rupees for this construction of port, airport, power plant, township, etc. Now, I am just raising a question subject to what your Lordship will say. Since in so many paragraphs in the first writ petition which is listed, the question of environment has been raised. The subsequent writ petition is hit by Order 2, Rule 2, Rule 3 and Sub-Rule 3 of the Civil Procedure Code. Because the law, your Lordships are aware, that once a writ petition or any proceeding or a suit is filed, if the cause of action is multiplicity, and if it is not included in that, subsequently it is barred to raise subsequent question. Therefore, my lord, I am raising the preliminary objection that will be the Lordship will decide. But I submit, my lord, let all the 3 writ petitions be listed after something. I have been asked by the Ministry of Environment and the Tribal Affairs Ministry to request the London Attorney General of India to appear in the matter because it's a high-stake 72,000 crores rupees matter. So kindly fix it after 3 weeks. All the 3 matters. Because I shall be raising the question whether this writ petition is maintainable at all, and it is hit under Order 2, Rule 2, Sub-Rule 3 and Rule 3 of the Civil Procedure Code.
The last occasion, we have recorded that affidavit in opposition has been filed.
Affidavit are
We
complete.
granted them liberty to file a reply if they chose to do so.
Yes.
In the affidavit in opposition, this point has been raised.
No.
So it can't be raised in this.
Because we are not aware. Subsequent writ petition when is filed, in the subsequent writ petition in the affidavit, we shall raise that point.
My lord, may I? The 2 writ petitions that my learned senior friend refers
Three
to, my lord.
writ petitions.
2 writ petitions that my learned senior friend refers to are WP 16 and 17. Both relate to the eco-sensitive zone notified around 2 protected areas. The writ petition that is listed today before your lordship, so pleadings are completed. This pertains to challenge of orders passed under the Forest Rights Act. No way connected in whatsoever manner with the eco-sensitive zone notified under for the Campbell Bay National Park and the Galatea National Park. Not connected at all. These, my lord, are simpliciter challenging 5 orders. 4 orders, my lord, passed under the FRA and an NOC issued by the Ministry of Tribal Affairs, all of which pertain only to the FRA, the Forest Rights Act. Why did these 4 orders within a span of 23 days? The administration has said the consent of the Nicobaris and the Shompen for forest diversion was obtained, and all claims under the FRA were settled. Only these two issues.
In fact, we recorded your submissions in the first order.
Yes, but because originally
so what the learned additional solicitor says is, let all the 3 writ petitions be listed. And they want to raise an objection. We can't prevent them from
correct. My lord, I'm saying my only thing is this: on the day of admission, my senior friend had an objection to say that this all matters were pending before the NGT. Therefore, my writ petition I have to be non-suited. There is no commonality. NGT was not, my lord, anywhere in the picture dealing with the Forest Rights Act question. Those 2 writ petitions, pleadings have not been completed. Even counters have not been filed. This matter is distinct. There, my lord, an attempt to present a fait accompli in terms of proceeding with the project, in so far as, my lord, awarding tenders, everything, my lord, is happening. My plea before your lordship is this: the liberty, my lord, for the respondent. It is within their right to raise this question whenever, even after I, my lord, make my submissions. My request is this. I have a short note on submissions, a key to my submissions. I'll circulate it to my learned friends. I'll give it to your lordships now. My request is if I may be permitted to finish my submissions whenever they argue at their convenience.
Piecemeal, it suits you, Mr. Yogeshwaran, to say so. The difficulty we experience, you can't.
No, I understand. I understand. I'm only saying that they will not, my lord, be able to finish it in a day.
That is true, but we are not going to fix like that because we have got motions which are pending.
Understood.
There are a lot of pressure. So what the Union of India's objection is that the other two writ petitions are barred by principles of res judicata or whatever it is. So let all the three writ petitions be listed. In the meantime, probably they will file their affidavit in opposition.
And these other two matters are due to appear on 10th April by your lordship's order dated 20th February 25.
So we can adjourn that also.
Yes.
You file your affidavit in opposition.
Yes.
If you want to raise this issue, let them.
Yes. Yes,
They will
I'm
answer
humbly
the-
pray for that. Because the first writ petition, your lordships have been pleased to record the question of maintainability.
Yes.
And the second, I shall take this question of maintainability, whether the first writ petition is to be dismissed or it is to be amended. These questions we will raise in the affidavit in opposition to the second writ petition.
My lord, with great
Hit
respect.
by order to Rule 2 of Civil Procedure Code and 3.
Your lordships, with great respect. If this objection, let me assume, my lord, that the union's objection that my second two other writ petitions are barred by res judicata. Those are fatal to those two writ petitions. My writ petition that is listed today before your lordships, the pleadings are complete. Where pleadings are complete is untouched by that. Today, my lord, assume
Then
even
we
those
will do a
fail.
thing, they say that learned Attorney General has to appear.
Correct.
You take a date, let it come.
Hold on. My only request is this. My
My lord, in this writ petition also, I am appearing on behalf of respondent number 4 to 8 for Andaman Island, led by Mr. Shatabru Chakrabarty, senior advocate. My lord, in this matter also, we have taken the point of res judicata and we are saying that this matter is not meant. We have given in our affidavit in opposition how this is barred by the laws of res judicata. So, my lord, let these matters be fixed together. There is no problem if all these matters are fixed together and hard together at one point of time.
My lord, for res judicata to apply, there needs to be an adjudication. Mere filing of 3 petitions, my lord, does not attract the principle of res judicata.
No, we are saying that has already been.
Anyways, today, my only request is this. My only request is this.
For the present, we will not drag those two writ petitions because the date has already been given on 10th of April.
Yes.
On that day, we will decide what to be done in those.
Yes.
This one, whatever is the date suitable for learned Attorney General, let
Yes.
the date be.
Because I have been asked to approach the London Attorney General.
So what we can do is, tentatively, we will keep this under the caption to be mentioned.
On 10th.
No.
My
My lord,
or thereafter.
The delay that there is, my lord, some things here, my lord, are non-reversible. It is not like a money suit where I can be put back in the position. The restitution integrum, my lord, is not a principle that's even applicable here. My request is this. If the learned Attorney General is appearing, my lord, it's for the respondents. Any given day, I will only require, my lord, an hour and a half to finish my submissions.
My lord, my
lord, senior friend is there. They are, my lord, here.
Work has
We are not going to be able to finish this matter, my lord, on any day. They will not be able to, my lord.
Lord, your lordship had been pleased to record.
We have seen this, my lord. My only request is,
your lordship
this is a case where I will make, I'm not saying, my lord, I won't even give them my written submission. I'll give everything in advance. Let me, my lord, finish my pleadings, my arguments, so that, my lord, the matter is part heard. Whenever it's convenient to the learned Attorney General, my lord, they may make their submissions.
We'll fix this matter under the caption to be mentioned on 10th April. On that date, you report as to what will be the convenient date for the learned Attorney General. He can appear online also.
Yes.
No issues. And probably he will start his submissions on that day.
But my lord, I submit subject to the correction. The point I have raised.
1.5 hours and all, we don't take your word.
This
we are in a motion list.
Understood.
If it is a specially fixed bench, a specially ordered matter, fixed for a particular division bench with no other assignments, then we can go on and go on.
No.
I mean, may I make
this matter, my lords, can time.
After I have come here, I have sat for 1 year, 2 months on one matter. We completed it.
My lord, in this matter, my lords may time me.
Lord, may I make one
time me. I will not take more than an hour and a half, my lord, to complete my submissions.
Pressing for this.
Yes, because matter, they are proceeding
He has
project. Let them say they'll stay their hands, my lord. Let them say they'll stay their hands.
Counsel, on the last occasion,
But Attorney General requires to hear your submission,
last
sir.
occasion, he has submitted, is recorded in the second writ petition, that is WPA number 16. The work has not progressed and started as yet. What is the urgency he is now making? And if,
issuing
my lord,
tenders and presenting a fait
my lord,
accompli.
In this writ petition, pleadings are complete, and the learned advocate for the petitioner prays for listing the matter for being heard at the earliest. The learned additional solicitor general appearing for the government of India raises a apart from reiterating the contention that this writ petition is not maintainable, would add that the very same petitioner has filed 2 other writ petitions, and those writ petitions are barred by the principles laid down under Order 2, Rule 2 of the Code of Civil Procedure.
And 3, Rule 3 as well.
And 3 as well. Order 2, Rule 2 and 3 of the Code of Civil Procedure. And they seek to raise this objection. Further, it is submitted that the learned Attorney General of India has
No, my lord, kindly record, I have been instructed to approach the learned Attorney General.
Further, it is submitted by the learned Additional Solicitor General that the ministry has instructed him to approach the learned Attorney General, to appear for the Government of India in these matters, since the stakes involved are very high and the project is of utmost importance. Since the other 2 writ petitions have been listed on 10th April, let this writ petition be listed on under the caption to be mentioned on 10th April, on which date the further course of action will be decided.
My lord, on that day, my lord, if it's convenient to your lordships, may I, my lord, commence my submissions and finish it off?
Let us see.
My lords may time me because this delay, my lord, it is the rest. This is something. This is not new. This is not, my lord, a novel.
My lord, the preliminary objection as to maintainability may be decided first.
My lord, on 10th of April, would it be, my lord, possible to write complete?
Let us see on
whenever it's convenient to the Attorney General, let them argue.
You are going to be ready always.
My lord,
Let it come on. Yes. Next. Yes.
আজকে ডেলিভারি কোনটা ওই তো one I am for the petition.
Yes. What was the prayer in the writ petition?
To kindly, Lord, I'll tell you, Lord. But the matter relates to, Lord, illegal construction.
No, it is his.
Well, I have the petition. How? But I do not know why the corporation.
We are hearing you. We are hearing you.
My Lord, kindly look to my written submissions.
First, please tell us what is the prayer in the writ petition.
My Lord,
come to page 31 of the petition.
My Lord, first, my Lord,
show cause as to why steps to effect demolition of unauthorized construction.
Kindly come to first, my Lord, kindly come to paragraph 5 of my petition.
Yes.
Paragraph 2, page 6. That an illegal and unauthorized construction without any sanction plan, that is G+5-story building, was suddenly constructed and or erected by the private responsibility along with her deceased husband, namely Shakil Ahmed as partners, at the adjacent and opposite direction of a tally shed house of the petitioners. It is made clear that 34A Dr. Sudhir Bose Road, ward number 77, police station of Wadganj, Kolkata 23, is a land and opposite to the said premises the petitioners have been residing in the Thika land where tally shed houses are standing. A small road that is 6 feet wide is standing between the house and of the petitioners and the above said unauthorized constructed building. The prevailing law mandates that on any land standing in a gully of 6 feet, sanction of building plan can be given up to G+2, and the law is barred that no sanction can be given and or granted above the 2nd floor on each land. The private responsibility and her husband, namely Shakil Ahmed, since deceased, had obtained a sanction plan G+2 on 3/1/2019, and later on variously constructed G+5-story building on the above such Thika land without following sanction plan and without keeping any vacant land. the unauthorized construction of extra 3 floors have been done on the gully of 6 feet congested populated area with thousands of persons in the basti land. Any little accident may cause immense loss of life and property and emergency relief in a dream. The said unauthorized construction obstructed the free flow of light and air of the adjoining premises, which have created environmental hazard in the locality, and the said unauthorized building is standing dangerously ill and posting a threat to the lives and property of the petitioners, their family members, and the local inhabitants. So the interest of the life and property of mass is involved. But kindly come to page 36. The sanction plan, my lord, G+2 I have annexed. They have admitted, my lord, that unauthorized construction has been done in their affidavits.
So this is the sanction plan for G+2.
Yes, my lord.
Sorry. Now what?
And my lord, the second 37 is the building, the unauthorized extra 3 floors, my lord.
Now what? You have sent a legal notice, etc.
Yes, my lord, everything, my lord. Then, my lord, then come, my lord, come. When I filed the petition, my lord, they have filed, as per your lordship's direction, they have filed affidavit or report. And they kindly come to the report, my lord. The report of the.
It is here.
The report dated by way of affidavit dated 18/9/2024.
18th December.
18th September, my lord, by the respondent number 8. Oh, respondent number 8.
Supplementary affidavit is there.
My lord, that is mine, my lord. The
report of by the 5th respondent.
By the police.
By the police.
Police, my lord, first.
Officer in charge. What could I?
My lord, kindly come at page 4. Paragraph 7. That the present respondent in area as respondent number 8, the officer in charge, and it is submitted that he always remains ready to provide sufficient police assistance to the personnel of the Kolkata Municipal Corporation if demolition proceedings are initiated from their end regarding the unauthorized construction work at premises number 35A, Dr. Sudhir Bose Road, Kolkata. Well, the admission.
All right. Now,
then, my lord, corporation also admitted.
Please show the corporation. Sir.
Corporation. Corporation, my lord, that is on 7/11/2024.
They are respondent number 5.
Yes, my lord. And my lord, second page, 4th line. How they treat this paragraph. Kindly see, my lord. The holy, unholy nexus, my lord, is clear. It is stated that the department inspected the concerned premises number 35. Upon inspection, it was found that an old 5-story fully occupied building existed at the said premises. At present, no new construction was found to be made. As per the office record and the database system, there is sanction plan that is at the only 3-story building. As per such department has taken, they are not clear. The unholy nexus is that they are trying to save that. My lord, I have submitted on oath affidavit, my lord. Kindly come to.
No.
And during the pendency of this writ petition, what the corporation did, I am very much anxious that how the corporation is trying to save that person. But kindly come to my supplementary affidavit dated 7th January 2025.
Yes.
My lord, kindly come at page 15, running page 15, paragraph F.
Running page?
Running page 15, my lord, inner page, my lord, 6. Paragraph F. My lord, I have given.
Yes, sir.
Yes.
My lord, there is a deep nexus and or connivance and or relation in between the Kolkata Corporation being the respondent number 5 hearing and the respondent number 10 who constructed the illegal unauthorized building, and the respondent number 8, the local officer in charge, police station. The deep nexus and the vested interests are deep rooted among them. So the illegal and unauthorized construction of extra 3 floors are not demolished under the unless under the original honorable court. The entire object of lawbreakers would be given a goodbye, and the illegal construction would remain as it is. As the next page, page 7 end, page 7 end. Now, the tricks to demolish the Kolkata Corporation would be a small portion of roof, 12 inches, would be shown demolished, and report would be given before the Honorable Court that demolition has already been done. In a writ petition bearing number 5194 of 2022, it has been fraudulently done. The tricks, unless the demolition work is not, my lord, started within the observation of the Honorable Court, but these tricks will go on. But kindly come to the judgments, my lord. My lord, kindly come to the judgment. To cut short the matter, my lord, I have.
This one.
My lord, written submissions, in the written submissions, I have.
No, there is one synopsis.
My lord, the written submission I have. My lord.
Yes, this one.
My lord.
Slim. Yes.
First page, my lord, is my written submissions, my lord. First page, the written submissions.
Very good.
The unauthorized construction of extra 3 to 5 floor of premise number so and so be ordered to be demolished on day-to-day basis. The respondent 10 be penalized for doing unauthorized construction. The respondent 10 be ordered to pay the cost of demolition. The Commissioner of Police, Lal Bazar, and the Deputy Commissioner of Police, Port Division, or the officer in charge of police can be directed to vacate the occupants of 3 to 5 floor, 5th floor, and the render all assistance while the demolition would be continued. The demolition will be continued under the supervision of the Honorable Court. The demolition will be started within a period of 1 month. The entire demolition process, that is 5th to 5th floor, be videographed and to report with affidavit before the Honorable Court. Well, next is something different, my lord. When, my lord, we raised that objection, my lord, the next task, my lord, the police authorities and the respondent 10, my lord, they hand in glove and, my lord, gave birth a false FIR against us. One man is airport, one man is masjid, one man is Salimar station, and one man digital era of digital what, my lord, digital model. All the mobile locations of 4 people were different places, my lord. The police authorities clubbed together and gave birth a false case.
And what did you do against that FIR?
First, my lord, that case was stayed before Justice Subhra Ghosh. And my lord, against the police action, well, I have filed a writ petition, my lord. I disposed everything, my lord, claiming 1 crore rupees compensation and the dismissal of service of the so-called police officers, my lord. This is a serious issue, my lord.
Yes.
And my lord, during the pendency of the writ petition, my lord, what they did, my lord, corporation, my lord, can you come to page? No, people, সাহেবকে একটু দেখাই সাহেবকে. They are above the High Court. They are above the High Court corporation people, my lord. আরে ওরা যে লেটারটা দিয়েছে রে ভাই, আরে ওরা যে লেটারটা দিয়েছিল সেটা বার করো, আমি তো দাগ মেরে দিয়েছি. এই যে kindly come at page 9 of my, during the pendency of the writ petition, my lord was going to decide the matter. Well, at that juncture, my lord, one letter has been given to my client by the corporation. Well, how dare, my lord? It is a contempt of court, my lord.
Page 9.
Page 9
of
what? Page 9 of my supplementary affidavit. My lord will see the unholy extract, my lord. Kolkata Municipal Corporation, as directed, you are hereby requested to appear before so-and-so person, special officer, on 7 for hearing of the above premises. But they are trying to capture my client under their control. If my client appears, they will come, they will say before lordship, well, we are taking process, we are taking, the writ petition have come, so let the matter be given a goodbye. This is the my lord attitude, my lord.
Yes. What do you say?
Against that, against that, well, I have filed that. Well, kindly come to the ratio of the judgment, my lord. I have made a research work, my lord, kindly. So, my lord, kindly come at page 9. Come at page 9 of this, my lord.
Written submission.
Of this submission. Page 9. Well, come, page 9. The judgment of the apex court and honorable high court are follows. Rajendra Kumar, Bharjatia and another versus UP Abbas, Exam Vikas, civil appeal number 3 judgment delivered on 17th December 2024. In the compilation, I have given all the judgments. Compilation.
Where is the judgment page number? The compilation.
Compilation. First. Judgment দেখো না সাহেব judgment চাইছেন রে বাবা এই যে first
you have filed one synopsis and one index.
Yes, my lord, all the synopsis, my lord.
Where is the judgment? Your
judgment, my lord, kindly come at page 14 of the first compilation.
40.
14. 14.
Index somebody.
Yes.
My lord. My lord, one judgment said, my lord. Paragraph 2, page 4. The district magistrate shall remain at present for the purpose of demolition of unauthorized construction. Paragraph 4, page 6. The common submission of the appellant was that shops are in existence for 24 years. Para 9, page 9, para 7, V, 5. There is no illegality or infirmity in the order of the Honorable High Court directing demolition of unauthorized construction. Para 6, page 15. Therefore, the fact is that the building has stood for 24 years, will not clothe the appellant with any right in law, and hence do not find any force in the contention of the counsel of the appellant. Next, my lord, page 20, para 19. It cannot be legitimate or protected solely under the rules of the passage of time or citing inaction of the authorities. Para 30, page 21. Lord Selborne in Madison versus Alderson, 1883, 8 appeal cases, 467 said courts of equity would not permit the statute to be made an instrument of fraud. Next, para 22. The appellants are directed to vacate the handover, the vacant premises within 3 months. Para 22. The respondent shall take steps to demolish within a period of 2 weeks therefrom. Para 25. B, page 35. Appropriate criminal as well as departmental action shall be taken against the erring official person concerned. Next, my lord, judgment, my lord, kindly come. My lord, it would be very short for your lordship, my lord, kindly, if your lordship, kindly case, come at page 11. 11, my lord. 11, my lord. Page 11. Dr. G.N. Hajuria and others versus Delhi Development Authority, 1995, 5 SCC 742. Before parting, we have an observation to make the same in that a feeling is gathering ground that where unauthorized construction are demolished on the force of the orders of the court, the illegality is not taken care of fully in as much as the officer of the statutory body who allowed the unauthorized construction to be made or make illegal allotments to go scot-free. Next, my lord, judgment, my lord, MI Builders Private Limited versus Radhesham Sahu, my lord. Page 21 of the, while directing demolition of unauthorized construction, the court should always direct an inquiry as to how the unauthorized construction came about and to bring the offenders to book. It is not enough to direct demolition of unauthorized construction where there is clear defiance of law. Next, my lord, Ekta Apartments Property Housing Society versus Municipal Corporation of Mumbai. There, my lord, the courts are also expected to refrain from exercising equitable jurisdiction for regularization of illegal and unauthorized construction, else it would encourage violators of the planning laws. Then, my lord, Supertech Limited versus Emerald Court Residence, paragraph 160, last line. Hence, illegal construction has to be dealt with strictly to ensure compliance with the rule of law. Then, my Kerala State Coastal Zone Management Authority versus McAdoo Municipal Corporation. Permission granted by Panchayat was illegal, that is the part, my lord. State of Haryana versus Satpal 2023 6 SCC 643. Under the circumstances, the High Court has committed very serious error in directing to regularize the unauthorized occupation and possession. Next, my lord, paragraph. The proceedings of demolition shall be videography, and the concerned authorities shall prepare a demolition report. Videography to be duly reserved. The demolition report shall be displayed on the digital portal. Next, my lord, judgment of our Calcutta High Court, my lord.
That is not required.
Well,
Cited the Supreme Court.
17 judgments. I have annexed the 70 judgments, my lord. My lord, kindly see the judgments, the ratio of the judgment, and my lord, another Supreme Court judgment is here also, my lord. The Supreme Court judgment latest, which I have, my lord, I have seen, my lord, the Supreme Court judgment latest, another one judgment. Deepak Kumar, this matter came from Calcutta to Supreme Court, my lord. Deepak Kumar, what your KMC, AIR 2013, Supreme Court, my lord, 927. The ratio of the within next 1 month, the corporation shall demolish unauthorized construction. The respondent 7 shall pay cost of this 25 lakh for violation of sanction plan. All the ratio of the judgment, my lord, including the High Court and Supreme Court, manifest or insinuates or indicates, my lord, unauthorized construction should be demolished and the compensation, my lord, cost should be imposed, my lord. My lord, in this case, my lord, kindly see, since the inception, the corporation, the next step, the next step, my lord.
Yes,
So, my lord, I am submitting, my lord, kindly one thing, just it is, my lord, It is between the court and the client. My client is given an undertaking before the Honorable Court.
This one.
Give an undertaking before the Honorable. What the undertaking my client? With affidavit, my client is giving the undertaking. Well, kindly come to the next paragraph, the next page, paragraph 2. I submit the two things, aspects seized from the inception. Unauthorized construction of additional 3 floors, that is 2.5, is proved and evident from the admission of the affidavit of the respondent 5 and 8. False FIR, bearing so and started against the petitioner, which would be evident from the CCTV footage and the report of tower location. My lord, then, that I submit, the petitioner submit, that if the above 2 allegations are proved false, I would be compelled to deposit cost of 50,000 only, which would be used for noble purpose of legal aid for wasting the precious time of the honorable court.
Now, this FIR 137 of 2024, what is the revision? I mean,
well, stay on a hearing.
Case number.
Case number 1-3. CRR 30. Well, I have.
Where is the order? Stay order.
Yes, just yes, 3044. 3044. 2024. Well, they did not. In spite of reported request, in spite of reported, I filed application. In spite of order, they did not file any report. How they will report? They cannot build a castle in a year, my lord.
CRR number?
CRR number 3044, 2024.
3044
of 2024.
Date of the stay order?
Date. And when I have filed a writ petition, that writ petition was assigned before your lordship, my lord. That Justice Ghosh told what I will do. Stay was granted. I told my justice that you have power, enough power under Article 266. I have filed this writ petition before your lordship, claiming 1 crore compensation to that so-called unholy police officers and from dismissal of service. That is also placed before your lordship, and your lordship assigned that matter to Justice Mrs. Hoffman.
Yes.
Now, yes, Lordship, in compliance with the Lordship's direction, I have already filed an affidavit by stating that at the time of inspection, no new construction was made.
No. Let us see.
Yes, Lordship kindly takes up my affidavit.
That
Response number 5. Response number 5.
Ranjan Das.
Yes.
He is the executive
engineer. Right. Lordship, yes, Lordship kindly takes up page 4, paragraph 4.
We will suspend him now.
No, the matter.
We will suspend him now.
But the matter is being processed.
We will suspend him now for this affidavit.
Lordship.
Is he trying to hoodwink the court?
No, Lordship kindly sees.
No, please answer the question,
My
Mr.
lord.
Counsel. You are representing a statutory body.
My lord.
Okay. He is a paid employee of the corporation. He has got a date of retirement also. Right and now we will suspend him. Right and now we will suspend him for his irresponsible affidavit which he has filed before this court. It's a clear attempt to hoodwink the court. If he thinks he is above law, we will show him what is the law.
No, that is.
He is not going to go home today. He will go to the correctional home.
No, I'll
from the office, which he is in SN Banerjee Road, he will go to the correctional home, not to his home. You never file such affidavit. You are a counsel representing a statutory body. You have to vet the affidavit before it is filed. Here is a case, admitted case of G+2 approval granted, 3, 4, 5 unauthorized. So what you should do? You should have inspected it.
No, we have.
Only one at a time. Okay. You should have inspected it. 3, 4 and 5 floors cannot come within a day. It is a lane of 6 feet. Where did they dump the construction material? So your fellows, your inspectors, your junior engineers have connived with the private respondent in indirectly assisting him to put up this construction. Maybe it is 100-year-old construction. You have no power of regularization. Even such power was there under various statutes framed by various state governments that have been struck down. Amnesty scheme was brought by various state governments that were all struck down. In one of the judgments, I think in this compilation it is there. It is called Consumer Action Group. Have you tried? Consumer Action Group. That matter arose from my home state, where 3 government orders were passed, where sanction was obtained for ground plus 3 floors and construction was made for ground plus 11 floors. Only once the Honorable Supreme Court granted a one-time exemption. The state government took advantage of that, and every 2 years they started issuing government orders saying that all right, he comes under innocent builder category who has put up 12 floors. Therefore, you pay at the rate of so and so rupees per square feet. As a regularization fee, we will regularize. All those government orders have been struck down. So therefore, what he should have done is, he should have signed a plain affidavit saying that, sir, I went and inspected. As per my office record, the approval is for G plus 2, but existing so many floors are there. And leave it at that. You have issued a notice under section 400. What is the penalty for 400? 300 rupees fine.
No. You
have not done anything. So therefore, can we not accept the submission of the petitioner's counsel?
No, I'll say
that your engineers are colluding and conniving with the private respondent.
No, may I now make my submission? But
we are going to direct immediate action subject to what the private respondent will say.
We'll go.
You see, the thing is, cosmetic demolition.
No, that will not do. That will not.
Cosmetic.
No, that will not do.
So your engineers don't think they can outsmart everybody.
No, but nowadays,
probably they can outsmart you, not the court.
No, may I just say this? But on earlier occasion,
all right, senior has come. Mr. Ghosh has come. So when such an affidavit is brought to you, before it is vetted and signed, you should say no. You place facts, sir. Statutory authority should place facts. You can never support this man, assuming he has put up construction unauthorized. Take action against him.
Of course, sir.
The entire lane. Take action against everybody. Why are you afraid? Court will protect you.
My lord. Well, I know, my lord, this bench, my lord, always protecting us.
Yes.
Earlier, but in many cases, the lordship also they get assisted.
This Ranjan Das affidavit is very.
Well, let me look into that, but I could not, my lord, go through the lordship and takes it up, and of course, my lord, the lordship, my lord, direction and whatever
today the matter is going to end. What is the private respondent stand?
First of all, my lord,
very influential man, your client.
My lord, that person died. Person who.
But the nemesis will continue, sir.
My lord,
sir, the person who illegally, inherited the estate, inherits not the estate. Along with the illegality, he inherits.
That is the widow of the earlier landlord. Private respondent number 10
created a first case, my lord.
Case
of rape.
Against your client. Widow of the original owner.
Widow of the original landlord. Now, whatever construction was done was around 20 years ago. I do not have any knowledge about how the construction was made or whether it was made within this sanction plan or
no, it is not. That's an admitted position.
If that's so, my lord, whatever citations my learned senior friend has cited, none arose from a public interest litigation. I am on a very simple point. My lord, kindly, if my lord, the petitioners, my lord, had filed a writ petition. My lord, WPA 15530 of 2024, same cause of action. They withdraw it, seeking liberty to file the same on a same fresh cause of action. Now, what they do, my lord, they do not approach that court. They come direct to this court for filing a public interest litigation. Now, whatever citations that has been followed by, whatever that relied upon my senior friend, arises from an orders that was passed not from a public interest litigation. All those citations, all those states, and they do not have a separate tribunal. Over here, my lord, the KMC tribunal has established. My lord, we have now the bench are operational. After my lord has passed orders, my lord, the judges have been appointed, the bench is now operational. Good, bad, indifferent, let KMC pass and demolition order. Let us contents. There are around 50 families in that 5-storied building. He ought to have made them parties.
Who indicted them?
I don't know. My husband, my late husband.
Then walk out. You walk out. Ask your client to walk out.
I may walk out of the premises. What about the 50 others?
He will deal with that 50 families. KMC will deal. Police will deal.
What about, that is the only point I was thinking.
Sir, we can't do anything, even assuming you are questioning the bona fides of the writ petitioner. The court can always discharge the writ petitioner.
Yes, my lord.
And entertain the matter. Here is a patent illegal. Assuming there is a fire accident. Admittedly, in a gully which is about 6 feet wide, nothing can go inside. Even an ambulance cannot go inside. At best, 2 or 3 two-wheelers can be taken inside. So in that, if you put up such a construction, whom are you putting in peril? Probably, all right, 53 families will get charged to death. The neighbors also will get charged to death. That's the problem, no? It is not your building alone. If your building tilts, your building catches fire, what about the neighbors? They are in a Tika land with a tiled property. That will be the first, they will be the first victim. You are in a concrete construction. Sir, you proceed.
Well, Your Lordship, all that I'm submitting to Your Lordship, I appreciate that is a total construction is unauthorized. Persons are in occupation. Your Lordship directs the police to vacate from first floor up the top floor and floor to floor. Then we may start the construction of the demolition of the structure with the assistance of the
4, 5.
My lord.
They will be evicted.
My lord.
They will be given an opportunity to vacate. If they don't vacate within a time frame, then the police will assist. Police will take action. Where is Mr. Who appears for the state? He was appearing online.
Additional government pleader.
No, he appeared just now.
No. Yeah,
Mr. Biswarup was appearing.
Mr. Biswarup Mollik.
He was in. Where is he?
He was online, he was online. He is online.
Online দেখা যাচ্ছে না তো online.
He appeared. This public interest writ petition has been filed, highlighting a menace which is plaguing the larger part of Kolkata and several parts of the state of West Bengal, wherein illegal and unauthorized constructions have been put up, and the authorities have failed to take any action. At the very outset, we shall deal with the preliminary objection raised by the private respondent, the present owner of the building, with regard to the locus standi of the petitioner to file this writ petition. It is submitted by the learned advocate for the private respondent that the writ petitioner had earlier approached the learned single bench of this court by way of a writ petition for the self-same relief. Somebody called Mr. Biswarup Basu Malik. Self relief, which was withdrawn with liberty to file a fresh writ petition, but without approaching the concerned court, this public interest writ petition has been filed. In our considered view, this objection is wholly untenable, since the petitioner has not only exposed the cause, his cause, the petitioner has exposed the cause of all the people who are residing in that particular lane, which is stated to be only 6 feet in width. Therefore, we reject the preliminary objection raised by the learned counsel for the private respondent as regards the locus standi of the petitioner to maintain the writ petition. The next submission of the learned advocate for the private respondent is that if as and when the Kolkata Municipal Corporation within bracket KMC passes an order of demolition, it will be well open to the private respondent to approach the building tribunal, which has been constituted under the provisions of the Kolkata Municipal Corporation Act, and seek appropriate relief. Such submission cannot be accepted in the instant case because the matter concerns the safety and security of all the people who are residing in the said area, which is a narrow lane measuring about 6 feet in width. Therefore, the private respondent who has admittedly put up illegal constructions or with illegal construction of third, fourth, and fifth floor in the premises without obtaining any building plan approval has absolutely no ground to plead for any equity being exercised in their favor. If the private respondent pleads for equity to be exercised in their favor, the private respondent or her husband, who was the predecessor in title, should have acted in equity. And since it has not been done so, the question of the private respondent seeking umbrage under the various provisions of the Act in order to escape the rigor of law cannot be accepted. Therefore, such contention raised on behalf of the private respondent also stands rejected. A report in the form of an affidavit has been filed by the executive engineer within bracket B of Borough Roman 9, KMC, Mr. Ranjan Das, dated 7th November 2024. To say the least, the averments in the affidavit shows that the officer does not want to place full facts before this court. And we may be justified in accepting the stand of the petitioner that the officer is colluding with the private respondent and trying to protect and shield them from any action against the unauthorized construction. The affidavit filed by an officer working under a statutory body should be clear and unambiguous and state the exact factual position. Any other averment which may give a color to support a particular party should be fully avoided, should not find place in such affidavit. However, on going through paragraph 4 of the affidavit sworn to by Mr. Ranjan Das shows, gives a color as if the said authority is attempting to protect the private respondent who has admittedly private respondent's property, which is of which third, fourth, and fifth floor are unauthorized. Several judgments have been placed by the learned advocate appearing for the writ petitioner in support of his contention as to how the cases relating to unauthorized constructions have to be dealt with. We may refer to a few of the said decisions. The Honorable Supreme Court in Dr. G.N. Kajuria and others versus Delhi Development Authority and others, 1995 5 SEC 762, pointed out that the authority concerned misused the power and allotted the plot earmarked for a park for a nursery school, which was condemned, and the order for cancellation of the allotment, beside recommending penal action against the authority concerned, was made. In MI Builders Private Limited versus Radhesham Sahu, 1999 6 SEC 464, the Honorable Supreme Court in clear terms held that there is no alternative to the construction which is unauthorized and illegal to be dismantled. In Isha Ekta Apartment Cooperative Housing Society versus Municipal Corporation of Mumbai, 2013 5 SEC 2013 3 SEC within bracket civil 89, the Honorable Supreme Court observed that the courts are expected to refrain from exercising equitable jurisdiction for regularization of illegal and unauthorized construction. In Supertech Limited versus Emerald Court Owner Resident Welfare Association others, 2021 10 SCC page 1, the Honorable Supreme Court held that illegal constructions have to be dealt with strictly to ensure compliance with the rule of law. In Kerala State Coastal Zone Management Authority versus Maradu Municipality, 2021 16 SCC 822, the Honorable Supreme Court reiterated that illegal and unauthorized constructions put up with brazen immunity, BRAZE, cannot be permitted to remain. In State of Haryana versus Satpal, 2023 6 SCC 643, the Honorable Supreme Court held that the High Court committed a very serious error in directing to legalize the unauthorized occupation and possession made by the original writ petitioners on payment of market price, and the same was quashed. The aforementioned decisions were taken note of by the Honorable Supreme Court in a recent decision in the case of Rajendra Kumar Brajchetia and others versus UP Evas Evam Vikas Parishad and others, Civil Appeal number 14604 of 2024, dated 17th December 2024. Some judgments. It is starting from page 34 of this compilation. You see, it's called index summary. 34. Take it from. So the Honorable Supreme Court in the set judgment affirmed the order passed by the High Court and issued the following directions.
My lord, para 4A and 6.
আমি বলি বিল কি করে মেনটেন আমি বলি বিল মেনটেন হবে দেবে না
Just the sum and substance of all the aforementioned decision is that there can be no concession granted to a person who has put up illegal and unauthorized construction, and there is no question of exercising any sympathy for such persons, nor the persons who were put in possession of the premises which have been illegally constructed. Having held so, the only conclusion which we can arrive at in the case on hand is to direct demolition of the unauthorized construction, which is the 3rd, 4th, and 5th floor in the building in question. Very interestingly, the learned advocate for the petitioner would vehemently contend that the officer in charge, Vatunge Police Station, Kolkata, 7,23,000, is colluding with the private respondent. And this is evident from the fact that a false FIR has been registered against the writ petitioner for the reason that he has approached this court and filed this public interest litigation. In this regard, a specific government has been made by the writ petitioner in their in their supplementary affidavit. And a case has been registered in FIR number 137 of 2024 on 27/6/2024 against the of which in this in this regard,
What the CRR file was.
in this regard, a legal notice was issued to the officer in charge, Watganj police station, dated 8/7/2024, wherein it has been stated that that stated about the circumstances under which the FIR which has been registered is illegal. Apart from that, they have stated that they will claim a compensation of ₹1 crore against the police authorities for committing such illegality. And we are informed that a writ petition in this regard has also been filed by the petitioner. The petitioner challenged the FIR number 137 of 2024 before this court in CRR number 3044 of 2024. And the case has been entertained, and there is a direction that no coercive steps be taken against the petitioners in connection with the said case. This order is said to be in force as on date. We may not be justified in making any observation as regards the FIR which is registered against the petitioner, but we prima facie feel that the FIR has been registered so as to silence the writ petition, not to proceed with the case against the private respondent. However, we refrain from making any further observations in this regard, as the Honorable Court is seized of the matter in CRR number 3044 of 2024. The writ petition was date of filing 10th July. The writ petition was filed before this court on 10th of July 2024. The matter appeared in the list on 1st of August 2024 and was adjourned to 29th August 2024. And on 29/8/2024, the appropriate authority of KMC as well as the 7th respondent police was directed to file a report in the form of the affidavit, and the matter was adjourned to 19th September 2024. Thereafter, the
What about the extension of interim? What about the extension of interim order which was granted
My lord,
on August 9, 2024? The interim order that was granted.
already extended and 11th April is the date of fixed, my lord.
11th April.
And interim order extended till end of April and fixed the matter on 11th.
Subsequently, the matter was heard on 19/9/2024, 11/11/2024, and 7/11/2024, where directions were issued.
My lord, kindly see.
However, no, after all the directions which have been issued, the administrative officer within bracket buildings, Kolkata KMC, issued a notice to the writ petitioner to appear for a hearing on 17/12/2024 in respect of the premises of the private respondent. In our view, the said notice is clearly an afterthought and probably to give an impression to this court that the authorities of KMC are taking action. Therefore, we hold the notice issued by KMC to the petitioner dated 10/12/2024 is a clear attempt to hoodwink make the present proceedings ineffective. Therefore, the step taken in this regard by the said officer, namely administrative officer, building department KMC, is deprecated. All right. In the light of the above conclusion, we issue the following direction. The
I direct the DC.
Following direction, considering the fact that taking note of the submission of the learned advocate for the private respondent, that there are about 53 families who are in occupation of the premises. The said persons who have been inducted either by the private respondent or by her late husband have no right to remain in the said property, since it has been confirmed that the constructions of 3rd, 4th, and 5th floor in the building is wholly unauthorized. Therefore, we direct the Commissioner of Police, Kolkata, to issue appropriate orders so as to enable the Deputy Commissioner of Police, 4th Division number 1, to deploy adequate police force to remove the occupants of the 3 unauthorized floors. The question would arise as to whether notice has to be issued to them. Admittedly, the construction being illegal, the occupants cannot claim any equity. Apart from that, the building has been constructed in a lane with a width of 6 feet, and it is not only not only the occupants of the illegally constructed 3 floor are at peril, but the other residents in the lane, which would include the petitioners also, are at peril. Therefore, the police authorities are directed to give notice to all the occupants to vacate the premises by themselves by 30th of April 2025. If any of them still continue to remain in occupation, they shall be evicted by deployment of adequate police force, and such process shall be completed not later than 16th of May 2025. After the 3 floors are vacated, the KMC shall initiate demolition proceedings, for which also the police authority shall deploy adequate police force, and such demolition shall be completed and a report be filed before this court along supported by photographs.
My lord, videography, my lord,
For photographs on 19th of June 2025. During the process of demolition, during the process of vacating the occupants of the building, as well as during the process of demolition, the entire events shall be videographed and such costs shall be borne by the Kolkata Municipal Corporation. List the matter on 19th June.
But I will communicate his lordship's order, my lord, to the Commissioner of Police, lord.
Before list the search. Needless to state that this writ petition being a public interest litigation, it goes without saying that it is not only the construction which has been put up by the private respondent which is to be dealt with, but the KMC authority should also cause inspection of all neighboring properties. And if any violation is found, the above directions will apply mutandis mutandis to such constructions as well. Of course, action be taken after issuing notice to the concerned notice to the owner/occupant of those properties. List the matter on so and so. Mr. Basu Malik, we have not made any observations against the police officer.
No, my lord, I will communicate. I have seen that.
No, this is very wrong, sir. Sir,
my lord. But it's a counter case in that area, lordship. What I will say, I will not to say anything, but it's better not to say anything.
They have given so much of particulars regarding mobile tower location. It's very, very doubtful whether these fellows, the complainants, were present in the police station.
Lordship. I will talk with the, my lord, office of the commissioner, and I will ensure that the order should be complied with, my lord.
One time you take stringent action, then automatically things will fall in place.
Lordship.
It will be a deterrent for the persons who want to do something like that in future. You go slow, then everything will be taken for granted. Next.
Well, matter will appear on 19th of June. Is right.
Serial number 2. My lord, this matter, my lord, can you remember, my lord, this is the ferry service of Sipur to Chatpal, my lord. Nothing has been heard, my lord. Your lordship directed them to, my lord, to accelerate the thing, and as well as arrangement for flying a vehicle there from that to nearest.
My lord, may I
that has not been done as yet, my lord.
My lord, I appear on behalf of the respondent.
May I respectfully invite your lordship, my lord, to the last order, my lord. Lord, straight away, my lord, kindly come to paragraph 4, lordship.
Please tell us, sir, what you want.
My lord, issue is, my lord, that regarding repair of jetty, work order was issued, and my lord, it has been, my lord, at the time when the last matter appeared on the last occasion, my lord, the tender was floated. Work order was not issued. My lord, now work order has been issued with a direction that the repair work has to be completed within 30 days.
30 days.
Now, secondly, my lord, shuttle service, my lord, the transport department is mulling over it has taken a decision. They have deliberated. They said, my lord, since it is a 2-kilometer distance between, my lord, Shipur jetty, which is under repair, and the other jetty is Ramkrishnapur jetty. It's a 2-kilometer distance. There is, my lord, a private bus service going on over there, and Toto service is also there between the two.
Toto will be expensive, no?
Yes. Electric, lordship.
Yes.
And, my lord,
Sometimes
in addition to that, my lord, this Ramkrishnapur jetty, I find, there also, my lord, the condition of the jetty is ramshackle and rickety. So, my lord, that is also, my lord, is under repair. The cost of 21 lakh has been allotted for repairing. So, my lord, if extra, my lord, load is being put on that particular jetty, there will also be a risk, my lord. May I, my lord,
Then what we can do is, we will close down all the government offices. We will also close down the registry because a lot of people can't come. So what is the big point? It is opposite, lady to be said.
Ramkrishnapur jetty.
So 21 lakhs, that also you close down. Let take 30 days to repair that, 60 days to repair that.
No, that one has not been closed, Lordship. It is functional.
But then you said it is rickety.
No, my lord, they have stated in paragraph 3, kindly sees, my lord. Paragraph 3, they say in paragraph 3, my lord.
Sir, these are all issues which we should not be advising you. It is not court's business. It is for the government to take some action on a public request.
So, my lord, within 30 days, my lord, they are going to complete.
Until 30 days, that's why you will say we will close your, which is closest to Nabana, which jetty is closest to Nabana.
Shibpur, my lord.
So therefore, nobody who is residing in the other side will come and report to the secretariat. How your Badli workers will come, how your group D staff will come. See, some I don't know, sir.
Well, many staff of our court also are coming.
Yes, that's why we'll close down this also. Stop filing from tomorrow. Why we should break our heads in all these issues? Very sad.
Toto service
seeking an intervention.
Supporting the government.
No, I'm not supporting the
government. He will not support the government.
Personal experience, Lordship, I have asked the people because I have, Lordship, contested last time. And my personal experience while talking to the people that it is not only about Shibpur, but also there are other jetties in Howrah. Those are non-operational presently. There are others. Lordship, I can disclose the data. Lordship,
Lordship, he is, my lord, enlarging the scope, my lord, of the other, my lord. Lordship, kindly, my lord, have a look at the report, Lordship. Work order issued 30 days.
Toto service, if you operate free of cost, we will accept. Let the government, how many 50 Totos, 60 Totos will be there? Let the government pay each of them 5,000 rupees. The Toto will go for 2 kilometers, come back 2 kilometers, come back. Toto is expensive.
Kindly appreciates, my lord, because of vagaries of nature, it was, my lord, swept away.
My lord,
work order has been issued, my lord.
There was a vehicle, my lord, at Namanno to Howrah, who is flying through the Forza Road. Please.
My lord,
he could have made that arrangement.
My lord,
it can be, it steamed up from the Namanno, touching, my lord, Shibpur Ferryghat, then Chukur, my lord.
Bus route, lord.
That bus route is always there. That is there.
Kindly, lordship.
That can be accelerated by, my lord, deploying more buses.
JT service. The ferry service is also not free of cost, lordship knows.
Ferry service is payable. But
so, my lord, with that money, if they can go from with the Toto from one side, kindly appreciate.
You are not able to stop.
No, work order is already issued.
You are not able to stop illegal buses flying. Buses without permits flying. Because of the order in the writ petition, public interest writ petition, you have taken some action. And blatantly, interstate operators are violating the permit condition. You are unable to do anything. One shuttle service, one government bus, probably morning office hours, 3 hours. In fact, during COVID time, how many buses were there? 12 buses were stationed here. So they will be here up to 8:30 and take all the employees, drop them in the railway station in the jetty. So that arrangement was there, and then after normal transport was restored, we said we don't want. Then
well, kindly give me a 1 week lordship. This
what is the bill? And the best thing, you know, they have raised a bill which runs to several crores. High Court doesn't have any money.
Part payments are being made.
So the bill was raised.
Yes.
Yes, pending.
Nothing comes free in life, sir, except mother's affection.
So even if except lordship,
mother's affection. So High Court, where they will get the money? We write to the Judicial Department. Matter is pending. Finance approval. Go here. Table. So then I took a decision. We will surrender. Hence, how you keep on raising bills? It went to crores of rupees. And those buses, at least you have to make good prayer before you get into those buses. Whether at all it will be road worthy to take you to the destination. That pending, you please ask your finance department. Some part payment was made. Otherwise, they were very, very angry with us. There's your same West Bengal Transport Corporation, WPTC. If you go in this side, you would have seen all the buses parked up to the State Bank. And where from we will pay that money? You do something for the welfare of the people, sir. That's all. See, if all of them are residing in and around Kolkata, this is not a problem.
But project of 21 lakhs. So how long? 30 days. So for that period, if something.
If you want, you can make magic, sir.
Lordship, kindly give me a week, let me deliberate on that, Lordship.
The army during flood situation, etc., they construct bridges on ballasts, which was very recently done in the neighboring state also. Construction will take place within 48 hours because relief material has to reach. People are dying. They have to be brought to the mainland, given treatment. Less than 48 hours. In spite of the rivers being so turbulent, you go to Uttarakhand. Water serving sport is very, very popular there because of the current. Even in that, rope bridges have been constructed in less than 6 hours. But if you have got the infrastructure, you have got the money, you have got everything, but you need to have the will. That's it. This jetty can be repaired probably within 7 days also.
Yes.
Only thing is deployment of requisite men and material, sanction of funds.
Yes.
In fact, you can make a advance payment also to the contractor. There are excellent contractors. Quick City Concrete has come.
No, they have already started work, my lord. So far as Shipur jetty is concerned, which is
We
non-functional.
will congratulate the managing director and place this report. Let your clients suffer.
Well, that is we are suffering. My lord, we are suffering with the red eyes also, my lord. It is not that this is today, my lord, is general public. Really, they're afraid to come to this court. They cannot ventilate their grievance here, my lord, because of the red eyes of the political parties there, my lord.
My God.
But apart from the, my lord, the
Lord,
executive, my lord, they are afraid
traveling
because
beyond the issue,
many public, my lord, the Sipur, not only Sipur, my lord, many persons coming from Andul also come down to Sipur jetty, my lord, to get hold the jetty to come to this court also, my lord. A densely populated area, my lord, Sipur and Howrah, densely populated area, my lord.
My lord, he is flagging in this matter, my
Public
lord.
interest litigation has been filed concerning the larger section of public, more particularly persons employed in various government establishments, as well as the High Court, who are unable to cross the Hooghly, River Hooghly, as the jetty at Shipur Ghat has been damaged. Earlier we had issued certain directions so that the authorities can give some relief to the people who are traveling, who are hitherto using the jetty, to enable them to commute to work. The managing director of the West Bengal Transport Corporation has filed a report dated 18/3/2025, in which it has been stated that the repair work of Shipur jetty has been commenced and a work order has been issued and it will be completed within 30 days. An inspection has also been conducted in the nearby jetty in Ramkrishnapur, and it has been noted that the condition of the said jetty is also not satisfactory, and a sum of rupees 21.35 lakhs is proposed to be is the likely cost that will be incurred, and it is stated that the matter is under process. As this court had in the earlier order observed earlier order had made an observation to the authorities to examine the feasibility of bus service between Shipur to Ramkrishnapur in the interganam. The report states The distance is 2 kilometers and there is regular Toto service. In addition, there is also one existing private bus service between those two jetties. And for such short distance, new bus route is not feasible. In our considered view, the stand taken in paragraph 4 of the report appears to be neither here nor there. The suggestion which fell from this court was to make an interim arrangement and not to sanction a new bus route. If the transport corporation has additional buses in the morning and the evening hours alone, shuttle services can be operated for the 2 kilometer. However, such suggestion appears to have not been well taken by the managing director of the West Bengal Transport Corporation. In fact, one of us, with my name, has also had certain other experience on the administrative side while dealing with the demand made by the West Bengal Transport Corporation. We say nothing more about this. Let the repair work be completed within the time stipulated and under regular supervision of the authorities of the Transport Corporation. And once again, we reiterate that the Transport Corporation can consider of operating shuttle bus services for the 2 kilometer distance in the interregnum by using government buses. With the above observation, writ petition disposed of. Next.
My lord, kindly, my lord, keep it pending, my lord, till the report comes, my lord. Otherwise, my lord.
You go to your MLS.
Lordship, may only once.
Letterji, no. Please call.
Serial number 3.
My lord, I beg to appear on behalf of the writ petitioner, my lord.
So much.
Kindly recollect this matter relates to, my lord, a financial scam in the, my lord, Lepcha Community Board, and your lordship has.
Yes, earlier.
Yes, my lord.
You find out.
Yes, that one writ petition. That writ petition is WPA 12 of 2020.
That order you are carrying?
Yes, in my mobile. That's
no, I remember that.
Yes, your lordship passed direction for filing affidavit by the bank. That is order dated 4 January 2020.
No, thereafter the matter came up, I think. No.
That order, I think, it's not available in the server.
Did you appear in that matter?
Yes. That is also the same issue, but the prayer is different, my lord. I have, my lord, checked the writ petition also. And I had, my lord, a talk with the, my lord, writ petition of that writ petition. And I shall also argue in that matter also, my lord. So, my lord, kindly, my lord, club this room matter and fix it.
In fact, the learned advocate who appeared, he came from Jalpaiguri.
Yeah,
correct?
Yes, yes.
That was the first time I saw him. He came from Jalpaiguri. And he also said that he was part of this Lepcha community or something.
The presence of the Lepcha board is very much necessary because everything has been done. Wrong thing has been done by the Lepcha board. So my prayer is, my lord, very restricted to my lord ED investigation.
All right. Let this writ petition be tagged along with WPAP 12 of 2023.
Next week.
The learned advocate appearing for the petitioner in this writ petition shall inform the learned advocates who are appearing in WPA 12 of 2023 by serving a letter informing that both the writ petitions have been tagged together. Give a date after 3 weeks.
Serial number 4 and 5.
4 and 5.
Item number.
No, this is my application.
Item number 5, I appear for the petition.
This is the matter related with
The burial ground, lordship.
graveyard ground, which was remain closed due to some allegations and counter allegations, and my lord was pleased to direct us to
Tag that writ petition with this, my lord, because one filed by one community, another by another community.
Yes.
So, my lord, there is some communal overtone over the issue, my lord. And my lord, there was a sitting across the table before a video to facilitate a resolution of the dispute. On the last occasion, my lord, I raised this issue, my lord. But since the direction was upon the
Yes,
petitioner
my lord, one direction further also was
to
there.
raise a boundary wall so that it will not be visible from outside when you are.
And we've directed you to file
Yes, that I have done, my lord.
addition of parties.
Yes, my lord, that I have done, my lord. Yesterday, when my client was suffering from cancer, he could not come. Yesterday, he has come. I could have filed it today. my lord.
You file it today, we'll have it next
I have
week.
already. My lord, may I serve these copies upon the advocate?
Yes.
And the community, I have to serve directly to them.
Yes. Let the application for addition of party be filed during the course of the day, and copies be served on the learned advocates for the parties as well as the proposed respondent. Next week it won't be possible, week after.
Yes.
Next.
Serial number 6.
I am for the pitch.
My lord, I am for the Risra municipality, my lord. Respondent
This is
number
our third round
3,
of
4 and
litigation, my lord. In spite of your lordship's specific direction, the water body could not be restored at the behest of the municipality. Kindly come to page 112 and 13. That was the first order passed by your lordship, sitting in public interest litigation, my lord. 112 and 113, the ordering portion, paragraph 6 and paragraph 6, my lord. 112 starts from paragraph 6 and 7. Those two paragraphs.
Yes.
Specific direction by your lordship to restore the water body. But it was not done. Now we came up in contempt proceeding. Further order was passed by your lordship, page 134, 136. The relevant page 136, last paragraph, the sentence starts with the executive officer of the municipality. 136. Then, my lord, pursuant to the order passed in contempt proceeding, the municipality, my lord, gave an opportunity of hearing to the interested parties and passed certain order directing. Kindly come to, it starts from page 140, relevant page 141. Only 7 except passing some orders, no effective step to restore the water body.
Lord, column 2, my lord, the encroachment and construction made on the pond area
Column
shall
number
be
1 and
removed,
2, page 141.
shall be removed by the concerned parties.
But,
Because, my lord, they have not encroached the
Then
properties.
what you do is
nothing.
Let the municipality remove it, recover the cost.
My lord,
Could I
yes,
add something? Lord, this is fight between trustees and trustees, evident from the writ petition itself. Kindly come to page 4, paragraph 2.
Trustees come beneficiaries of trust estate, so and so.
And my lord, page 35. So they are doing the mischief and they would not be removing. Kindly come to page 35. These Gangulis are all trustees. Gangulis are the writ petitioners. Encroachers are the writ petitioners. I mean the respondents. Kindly see the cause title.
Now, who is who are the writ petitioners? They are also
They are
part
the
of
Gangulis. They are the trustees. This is trust property in the Devoto property. This is.
All right.
And Sebait is Onu. Kindly come to page 36.
No, the private respondents are also trustees.
Yes.
So it's an infight between trustees.
Yes, and they will not remove. Kindly see now the order of passed by the executive officer at page 141. 141.
But these facts all were decided in the previous litigation.
Kindly don't try to hoodwink
the water body.
Kindly come to
I want, my lord, the compliance of that order. Nothing
you
else,
do
my
it.
lord.
Kindly come to page 141.
Your trustees have to do this.
Yes, my lord.
Let them do. Let them realize the cost from the parties concerned.
You deposit. Let the petitioner deposit.
No, we have not done it.
No, you had the public interest litigant.
Yes.
This aspect was not brought to our notice. That you are also trustee. The violators are also your co-trustees. So it is indirectly an internal dispute which you are trying to settle through a PIL.
Yes, Mr.
So
And
what
shift-
we will issue one direction. How much will be the approximate cost?
That
About
they can
50 lakhs is sufficient?
Yes, Milord, because Milord, there
20
are
lakhs sufficient enough.
several ponds has been converted.
And they put up Pakka construction?
Yes, Milord. Both of them.
Oh, two options. One is we will direct the Rishabh municipality to enforce this order. Second is you deposit 1 crore.
Yes, Milord.
Petitioners. Trustees will deposit 1 crore, which with that money, the Rishabh municipality will carry out the
Yes, Milord.
That will sort out the problem.
In that way, kindly adjourn the matter. We have to take instruction from the petitioner. We are not in a
we
position
will
to
discuss it now.
We do
That
not
is
have
the
the
problem. The petitioners are all
kindly adjourn for
particular
fortnight.
trust.
I shall take proper instruction from
And
the
this is
petitioner.
the second time the petitioners are before this court alleging that the private respondents have illegally encroached into a water body. The direction issued in the earlier writ petition was alleged to have not been complied with, and contempt petition was filed. And in the contempt petition, it was brought to the notice of the court by the Rishabh municipality that there are several persons who have encroached, and therefore direction was issued to issue notice to those persons and proceed with the matter. Pursuant to which action has been taken, and notices have been issued on 22nd July 2024. What is interesting to note is the private respondents are also trustees of the very same trust to which the petitioners belong. Therefore, this appears to be not a genuine public interest litigation, but it appears that to vindicate certain personal grievances of the petitioners vis-a-vis the private respondents. Therefore, the municipality cannot be faulted as they have taken action and issued notice, and they will take the matter to the logical end. However, if the petitioners seek for immediate implementation of the direction, then the petitioner should deposit at least a minimum of ₹1 crore with the Rishabh municipality. With those funds, the municipality will take action in accordance with the law. With the above observation dismissed.
Much obliged.
Next. 7.
My lord, annulment of patta, your lordship knows I have argued so many times. Section 49 of the Act.
Kindly allow me to submit.
একটু land reforms টা দেবেন তো judge সাহেবকে. Section 49.
At the end of the petitioner village, there is a land, my lord. Actually, it is a vastu land, but physically, my lord, it's a low land and water is lodging over there. And through that portion, my lord, what happened? The rainwater is passing through that. If it is, my lord, blocked, then, my lord, village will be in problem. My lord, there is this land was, my lord, vested land, and it was settled to the private respondent 8 and 9. My lord, they went to fill up this pond, and there is a, my lord, 140 proceeding, and the proceeding we obstructed them, the villagers. There is the inquiry was made, my lord. Kindly come to page 24, my lord.
Yes, revenue inspector.
Yes, my lord. Kindly see and may I read?
I have read.
Yes, my lord. So, my lord, this is the actual position of the land, and my lord, kindly see the photograph I have annexed. That is a, my lord.
It is admittedly it's a
My
bust.
lord, yes, my lord, that is
So,
true. My lord, what I am on, my lord. We are not against the, my lord, the settlement of the land. My lord, we requested the authority to settle the another land to the, my lord, the private respondent, and there is a, my lord, series of proceeding is, my lord, going on from 2015. Hearing was done, inquiry was made, and authorities said yes, we are giving the another land to the private respondent, but they are not, my lord, settling the dispute. And for this, my lord, serious breach of peace is going on from 2015. We are requesting, my lord, kindly direct the authority to settle the another land to the, my lord, private respondent, and this land may be, my lord, kept for, my lord, drainage of water. That is one only. And the
page 7, para 9, writ petition.
And the authority also, my lord, assured us that we will do this.
Can't compel them to give alternate.
Well, kindly direct them to
An
consider
annulment
this,
is not possible.
Annulment they don't want. Paragraph 9 of the writ petitions.
Yes.
Page 7.
Yes, ma'am. And they have also assured us, but
Can't
they are not doing.
We can't issue a mandamus.
Well, kindly direct them to consider, my lord.
It has been considered and turned down.
No, my lord,
Petitioner seeks for issuance of an appropriate direction to prevent filling up of a water body. From the documents annexed to the writ petitioner, it reveals that the classification of the land in question is Vastu. If that be the classification, the question of treating it as a water body would not arise. In a public interest writ petition, there cannot be a prayer to change the classification of a land. The petitioner alleges that there was talks going on, and alleges that the BLLRO Barwan had given a proposal of alternate land by way of righty settlement in the case of Kashinath and Dolly Chaudhary to the SDO Kandi, wide memo dated 19/4/2023, seeking his instructions and permission for approval of the new patta and annulment of previous patta. If the authorities have taken certain action, it is up to them.
My lord, it has been taken already. Annulment of patta has been rejected.
Cancel that sentence. The learned government council.
My lord,
placed
strategy, I'm sorry.
copy of the order passed by subdivisional officer and subdivisional magistrate Kandi, Murshidabad, dated 31/1/2025, wherein the prayer for annulment of patta has been rejected. In such circumstances, the direction sought for in this writ petition cannot be granted. Next.
Deeply obliged.
But I appear for the respondent number 1.
My application. My lord, allegation is that, my lord, the private respondent, this Emma dealer, he is running on the basis of fake ration cards.
4,000 fake ration cards.
So, my lord, allegation, 4,000 fake ration cards. My lord, this is a very, my lord, let my learned friend first place his case, lordship.
My application, my lord. The allegation is that the respondent number 10 is the ration dealer, as stated in paragraph number 7 also. He is running the ration shop with nearly 4,000 fake ration card holders. My application is that let an investigation is be made on this basis of this allegation and take appropriate action on this also. I have stated in my application, and the prior portion is also that.
Now, page 17, from page 17, you have said fake ration card.
Yes, ma'am.
And these are all particulars collected by the petitioner.
No, I have made inquiry, and report is that.
No, the status says all of them are deactivated.
Lordship.
So therefore, you say 4,000 cards which are deactivated are now being used.
No. His simple bold statement, he wants the honorable court to go for a roving inquiry for him without doing any homework. Kindly, this is a bold statement at paragraph.
Consider his representation.
Already, my lord, he has not done his homework because already matter was inquired into. He was show caused, penalty was imposed. My lord, this is the report. So, lordship, may I respectfully hand over this report, lordship.
Then once again, he has been using it after paying the penalty. No.
No, lordship. As such, my lord, there is lordship. And, my lord, lordship, kindly have a look, my lord.
I have no such information.
Lordship, kindly see page 3, my lord, of the report. It refers to a show cause, that is at page 47. At page 47 is the show cause, my lord.
No, but then 50,000 penalty is a very paltry sum.
No, lordship,
4,000 cards.
No, it was not only, my lord, this kindly sees the finding, my lord. 47 is the show cause, and kindly sees, my lord, page 59 is the order. Conclusion, my lord, last 2 paragraphs. Now, my lord, so far as the deactivation, my lord, of these fake ration cards are concerned, there is a scheme, my lord, provided in the control order of 2024, paragraph 5. So Lordship, if he still now say that deactivation, fake ration card is the issue, my lord, then paragraph 5 of the scheme of the control order of 21 has to be taken recourse to.
All right, you take
Lordship.
action.
Lordship.
Now, according to this order, if
Authority was not satisfied with the reply of the authority.
shortage of 10.87 kgs of rice, so and so atta, probably during handling loss, PDS so and so for days.
No, his complaint, my lord, petitioner's complaint has been taken care of at page 59, last paragraph kindly sees. Page 59, last paragraph. Enquiry team also inquired on the basis of the list provided by the complainant Syed Soleiman Azad, the petitioner before your lordship. So that has also been taken care of, lordship.
Now, what you have to do is, all right, now you have taken action against the MR dealer. So far as those ration cards, you have to deactivate.
If at all activate. Paragraph 5, my lord, it is provided for 2024.
You examine and deactivate.
Lordship.
What is the procedure? The petitioner alleges that
Let paragraph 5 of the order, lordship.
the respondent who's a MR dealer has utilized 4,000 fake ration cards and swindled off the public distribution items. Since the representation did not evoke any response, the writ petition has been filed. The subdivision officer within controller within bracket FNS, Malda Sardar has addressed the joint director within bracket law, Department of
Food and supply.
Food and supply, lordship.
Food and supplies, dated 27/2/2025, from which it is seen that pursuant to the complaint which has been lodged with the petitioner, an inquiry was conducted and an order has been passed against the 10th respondent dated 21/2/2025, and a penalty has by imposing a penalty of rupees 50,000. It is not clear as to whether any appeal has been filed to the appellate authority against the said order in terms of para 57 of the control order. Thus, it appears that some action has been taken against the 10th respondent, and what appears to be true is that fake ration cards have been used. Therefore, the authorities should not stop with this exercise, as there is every likelihood that the 10th respondent may file a statutory appeal before the appellate authority. Therefore, the steps should be taken for deactivation of the fake ration cards, namely that which were issued in the name of non-existent person or persons who are dead. In this regard, sufficient power has been provided under
paragraph 5 of the order.
Under clause 5 of the West Bengal Targeted Public Distribution System within bracket maintenance and control bracket close order 2024.
Kindly see subclause 4, Roman 2, multiple ration cards.
And who will be the authority to take action?
That is when the subdivisional controller, lordship.
Therefore, we
FNS.
direct the subdivisional controller within bracket FNS, Malda Sardar, to which respondent? To proceed to take action in terms of clause 5 of the control order. The authorities should also examine the aspect from the criminal angle as to whether the 10th respondent has colluded with other persons and conspired to commit this illegality. And the authorities should not be satisfied with just passing an order under the relevant provisions of the control order. With the above observation, the writ petition stands disposed of.
Lordship.
My lord, the report of the inquiry.
My lord, to examine whether those curds are in circulation, my lordship. Kindly, my lord.
My lord, they,
In
I
accordance,
have a copy of the report, my lord. Inquiry
please give.
Lordship, may I take back the book, lordship?
Individual service.
Report a copy.
Serial number 9.
Report a copy.
It's directed against, my lord, the illegal construction which has been made by the private respondent on the footpath, encroaching the footpath. Kindly comes to, my lord, the private respondent is a very influential, my lord.
Mr. Lahiri, first you file a writ petition for this area in and around the High Court.
Encroachment.
Well,
Yes, yes.
In fact, my lord, I quite sometimes.
Can you walk from this A
Yes,
gate?
absolutely, absolutely. My lord, I, my lord, drew attention of this honorable court, the then Chief Justice regarding this. Well, it is now difficult to walk from the
many
library
are there.
through the corridor.
One fellow is selling green salad. There is a puri sabji shop. One fellow is selling stationery items. All full line.
And the
Lordship
huge
comes in the night, my lord, the entire area, my lord, changes.
This suddenly your client woke up one morning, saw this BP Podar hospital. Oh,
No, my
this
lord,
fellow.
this is not, my lord. This particular gentleman has been, my lord, has
No,
been,
no,
my lord, highlighting, my lord, from
dealt with the
2013.
another matter. One person who is a very, what is it, public spirited citizen.
Public spirit.
He got up from his house in Salt Lake, walked down the road and found all the hospitals have encroached place. We dismissed it then and there.
Salt Lake.
This is new Alipur. This is nothing new here, sir.
Lord, footpath, my lord, cannot be, my lord. Let them do it in their own territory, my
Footpath
lord.
cannot be.
Footpath is, my lord.
Cars are being parked on the footpath in the High Court. Advocates' cars are being parked in the footpath. You see the entrance from the stadium area. It's on the foot. Therefore, all staff who come walking from the ferry ghat have to walk on the road.
My lord, this is, my lord, based on, my lord, the inaction of the municipal authorities, my lord, corporation.
Philanthropic welfare activities. What is the philanthropic welfare
Yes,
activity?
kindly takes up my supplementary affidavit, philanthropic and welfare activities, my lord, which I have.
We will not accept.
I have
Pleading should be here.
But I have pleaded.
No, supplementary
I have got
affidavit is supplementary. It can be filed with the leave of the court. Well, there is some axe to grind.
Well, this is supplementary, my lord. I have annexed, my lord, 2013
This
papers.
public interest writ petition is
My lord,
alleged to have been filed
my lord,
by a person with
kindly allows me to
several
place, my lord.
philanthropic welfare activities.
My lord, kindly allows me
fail
to
to
place.
understand. We fail to understand as to under
Lord, I have
what
got on record, my lord.
circumstances
Kindly
the
allows me
petitioner.
to place, my lord.
No, you take it on appeal, sir. We fail to
No, my lord,
understand.
kindly. This
as
is,
to
my
how-
lord, this is a,
as to
I have,
how
my lord,
the
highlighted a very
petitioner all
important,
of a
my
sudden
lord.
woke up and found that
There are
are
very, my lord, influential persons
If
who
the
are, my lord, trying to,
petitioner
my lord, encroach
is
a
so
footpath, my lord. I am
concerned,
trying to, my
he
lord,
should,
bring it to your lordship's notice, my lord. Lordship kindly allows me to place it at
he
all.
should take action for the entire city of Kolkata. Therefore, we find no reason to issue the direction as sought for. However, this will not prevent the petitioner from pursuing his representation with the authorities. Dismissed with observation. Sorry, Mr. Lahiri.
My lord,
Next.
kindly allows me to, my lord, place my supplementary affidavit.
We will sign the order, you file an appeal.
Serial number
My
10.
lord, my lord. Then kindly gives me leave to, my lord, amend, my lord, and come back, my lord, with a fresh one, my lord.
We are in the next case.
My lord, kindly, my lord,
Sorry,
this
sir.
leave, my lord,
Sorry, sir.
this might be a drafting mistake. This might be a, my lord, mistake
no.
on my part also, my lord. The records are there with me.
There is something more than what meets the eye here. This is not the first time, Mr. Lahiri. Probably you are appearing here. We have
Yes,
seen
lordship is
dozens
taking
of cases.
every day. Lordship is taking, my lord, matters, and lordship is interfering in some of the matters. My lord, I'll be praying, my lord, this, my lord, blatant violation, my lord. Construction on the footpath, my lord.
Yes, you pursue your representation. We are on the next case. Please, next.
Well, pursue my representation, my lord, before the appropriate forum, my lord. Can in the appropriate forum.
Item 10.
I am but the petitioner.
What is this Inland Fisheries Act?
Lord, this is the Lordship. This is the illegally filling the water body. That is the water body
was originally belonged to Lordship the Maharaja of the then Andaman district, and it was the measuring about 1.18 acres. Nowadays, the 50%.
Lord, in this matter,
Nowadays, the 40% of the water body has been encroached.
What happened to your representation?
Representation, no steps has been taken.
Lord,
till date.
give me the two copies.
Representation is Lordship kindly
This
page
copy,
43.
We saw that. What action was taken, sir?
Lordship, action will already notice, my lord, has been issued upon the wrongdoers. Upon inquiry by the revenue inspector, it has been found, yes, there are some constructions going on. And my lord, notice was issued, my lord, on 3rd March 2025. Lordship, kindly.
my lord, in this matter, Mr. Deobhuti Sardar is appearing on behalf of the petitioner.
So, my lord,
Now,
kindly
he's
see the
saying
note.
he's in another court, my lord, kindly make it.
Petitioner means?
Private respondent.
Private respondent, Deobhuti Sardar.
Oh my God, you are representing somebody, you tell the name. He is for the petitioner.
I am for the petitioner.
I am for the state. Lordship, kindly see the last page of the report, Lordship.
Now they have given a report saying that already 4C notice has been issued.
Yes,
and they have
Lordship.
undertaken to complete the process.
Logical conclusion, Lordship.
It will take some time, probably 1 month.
Lordship. Kindly, my lord.
This writ petition has been filed, praying for direction upon the authorities to take action in accordance with Section 17, Capital A of the West Bengal Inland Fisheries Act, 1984. The petitioner has approached this court since the representation given by them was not acted upon. The Learned Government Council has produced a copy of the report filed by the Block Land and Land Reforms Officer Bardwan Sardar 1 Purva Bardhaman dated 5/3/2025, from which it is seen that after an inquiry was conducted by the revenue inspector in pursuance of Section 4, capital C, within bracket 5 of the West Bengal Land Reforms Act 1955, notice has been issued to all the recorded rights. They provide office memo dated 3/3/2025 with the direction for restoration of the plot in question to its earlier position. Copy of the said notices have also been appended to the report. The Block Land and Land Reforms Officer has undertaken that a further action will be taken as per the provisions of the WBLR Act 1955. In the light of the stand taken, we direct the Block Land and Land Reform Officer to proceed in accordance with law after notice to all concerned and pass recent and take appropriate action within a period of 2 months from the date of receipt of the server copy disposed of. Next.
Serial number 11.
Number 9, my lord, we have optical conversion.
Serial number 11.
11, my lord, I appear for the private respondent number 15.
My lord, item number 11, my lord. I'm bringing not to them. Sorry, sir. Not to them.
Next.
Serial number 12.
I appear for the state respondent, my lord.
I appear for the Calcutta Municipal Corporation.
Illegal occupation and food stalls.
Stalls in KMC areas, my lord.
Mahatma Gandhi Road.
What to do? We can't.
Well, Lordship, direct because he made a representation. Let the authority, now the time bending committee and the authority is there. Let them take a decision on that for the grievances of the petitioner.
No, but he has given a commissioner of police he has given, then officer in charge, Borough Bazaar, commissioner, Kolkata Municipal Corporation. Football. These eateries, what to do? Suppose we take action, where they will go?
That is one of the basic of the issue. Now the authorities, my lord, the LOC knows, my lord, the hawking and non-hawking zone in terms of
No,
the
let
central
the matter be referred to the hawking committee.
That is I'm submitting, my lord. You should direct that because town vending committee is there.
Town vending committee.
This representation may be taken into consideration by the town vending committee. They will ascertain whether it has already been declared as a non-hawking zone. If it is a non-hawking zone, then it will be incumbent upon the authorities to, my lord, remove those persons to other places, my lord, where the hawking zones or some other things has to be done.
Petitioner, by way of this writ petition, state that there are several people who are street hawkers and occupying the footpath, and no action has been taken by the authorities despite representation dated 16/9/2024. Similar representation has also been given to the police authorities. However, no postal acknowledgement has been filed in the writ petition. It is submitted by the learned advocate appearing for the Kolkata Municipal.
I find, my lord, pardon me for interrupting. The note representation does not appear to have been made to us. Is the officer in charge and the
page 19 এ রয়েছে দেখুন।
is 19 আছে?
The learned advocate appearing for the
Oh, I see,
Kolkata
yes.
Municipal
We should do that.
Corporation submitted that the town vending committee has already been constituted and the matter will be looked into by the said committee. Therefore, we direct the fourth respondent to forward the representation given by the petitioner dated 16/9/2024 to the town vending committee, who shall proceed to take action in accordance with law. The petitioner is directed to submit one more representation along with a copy of the earlier representation and a copy of this order to enable the town vending committee to proceed in accordance with law. Next.
Serial number 13.
Should
I appear for the state respondent, my lord? Time for the petition. I beg to appear on behalf of the Union of India. Kindly come to page 30.
Lordship, I appear for the Union of India.
Kindly come to page 37 of my application.
Respondent municipality. I am for respondent number 20.
Page 37, my lord.
Page 37.
The municipality, my lord, by way of a resolution taking 20,000 rupees. My lord, this is a matter pertains to Pradhan Mantri Awas Yojana. Lordship knows, well, there are three components. One, the beneficiary's contribution, state contribution, as well as the contribution from the central government. Now, in addition to that, the municipality charging 20,000 rupees from each beneficiaries for, my lord, on the in the name of development fund, my lord. Now, my lord, many of the beneficiaries who are unable to pay this amount, their names were struck off. And, my lord, this is a report of, my lord, the Accountant General of West Bengal, my lord, which as well as in page 42, my lord, the report of SUDA, my lord, that is the State Urban Development Agency. They also requested, my lord, them to refund the money to the beneficiary. But till date, my lord, my instruction, my lord, they have neither refund the money. Even, my lord, we have asked, my lord, the municipality that on what development fund this money was, my lord, the incurred expenses. Their reply says, which is that.
No, what is ID cost?
But that is infrastructure development cost.
No, my lord, page 48, they are saying. Number 2, reply of my RTI application, the Office of the Accountant General, West Bengal Local Audit Department, CGO Complex, such and such, টাকা ফেরত দেওয়ার কোনো নির্দেশ দেওয়া হয়নি. That means they are not asked them to refund the money. However, from SUDA, they have asked them to refund the money, which is that very next page, page 49.
4950 is the direction.
50 is the direction. And, my lord, if your lordship kindly consider page 51, this is also a reply. My lord, though it's in vernacular language, my lord, is a reply where, my lord, we have asked, my lord, the purpose of.
And what happened after this additional secretary's order?
Thereafter, my lord, we have made several representation, my lord. My lord, in this petition, we have a threefold prayer, my lord. First, my lord, an inquiry. Secondly, refund.
No, inquiry has already been conducted by the State Urban Development Agency.
That was
Then
conducted, but
the Office of the Accountant General has also conducted an audit. And they have said that you have to refund or something else.
like in my lord,
And what did the municipality do about it?
May I just answer to Lordship's question? Well, this is PM Awas Yojana or manner the urban local. Well, so far as the allocation of funds for construction of houses, etc., dwelling units, well, the funds are allocated by state and center. Whatever funds were allocated by the state and center has been given to the beneficiaries. There is no dispute. Separately, a sum of rupees 18,000 for one financial year. Later on, sum of rupees 20,000 for the balance financial years, but now it's not being collected. All was collected from the beneficiaries for the purpose of infrastructure development, because it is not all about dwelling units. The roads are to be constructed. Well, at that point of time, the municipality was totally cash strapped. Didn't have enough cash to construct the roads and etc. Each and every penny which has been collected from the beneficiaries on account of this infrastructure development has been accounted for. It is subjected to internal audit. It is subjected to the CAG audit. Your audit report will reveal what is the collection and the expenses.
No,
Account for everything.
I don't think so. Their allegation is that you swindle the money. That's not the allegation. The allegation is that it is an unauthorized collection under the scheme. Three components are there according to them.
It's not under the scheme. May I make it clear? But as an officer of the court, I must apprise your lordship what happened. When the scheme was launched, it was launched for the entire nation, and obviously for West Bengal too. Most of the municipalities could not even implement the scheme because of the other cash requirements, etc. Our municipality was totally cash strapped. So what they did, they extended the benefit to the eligible beneficiaries. And they also requested the beneficiaries that you pay at least 18 to 20,000 so that we can construct the roads, make sewage system and also drainage system.
Now this 20,000 you deducted from which component?
No, nothing deducted. Additionally, payment was made.
And
whatever has happened, I must appeal you.
The person who are unable to pay, their names were struck down.
No, that they have said on page 50.
This is the case, but that is what has happened. Because it is for the, I tell you, Lordship, for the purpose of infrastructure development, some amount is allocated by the state government. The rest of the amount is to be provided by the municipality out of the municipal fund. Funds were not at all available.
In the report says, one beneficiary bearing ID number belonging to...
That has been taken care of. The SC/ST, that
and he has deposited 45. But this is unauthorized collection. You might have spent it for a laudable purpose. No issues.
Right.
You are a local body, you are supposed to provide. You are cash strapped. As a result, you ask the citizens. But now the authorities hold that this is an unauthorized collection.
May I just...
Now, if you have got funds, you...
My lord, may I just submit one thing?
Yes.
Kindly come to paragraph 3 of the writ petition at page 5. Now, this scheme has been given in detail. This is called Pradhan Mantri Awas Yojana. Fund allocated by the government of India to the state government for construction of dwelling house for the poor. How is this diverted to the road or by the municipality? No, the scheme is being diverted. No.
ASG perhaps has misunderstood me, or I have not been made myself clear to the court. It is not diversion of fund at all. Funds were allocated by the state and center in equal proportion, or there may be some difference. This was collected additionally. And that would be evident from the annexures to the writ petition. The RTI query was made in January and the direction is subsequent to the RTI query that you refund. This blame game cannot continue.
No, this question, no question of blame claim. No question of blame claim.
The Accountant General and other departments have held that the collection is unauthorized.
May I just kindly give me an opportunity? May I place on record whatever is there, what we have done? Then your lordship, whatever direction your lordship will pass, we will abide by that.
No, you deposit that 439.42 lakhs. that report has become final. See, when the accountant general conducts an audit, he will the officers will record what is called audit paras.
Yes, audit objections,
Audit paras.
Yes.
So it is well open to the concerned agency or the department to reply to the para or the objection or to concede to the and rectify the defect. Now, as long as this report of the year 2022 at page 37 remains intact, the collection is undoubtedly unauthorized.
May I, there's another aspect to this. Apart from this 20,000 collection, which your Lordship has rightly pointed out, Lord, the cancellation of the beneficiaries who could not deposit the 20,000.
Yes, my lord.
This is of even major, my lord, consequence. The beneficiaries.
That will directly hit at the scheme.
Yes.
Yes.
And my lord, so far as as my learned friend saying that they had made this expenditure towards the development without call for tender, that is also reveals from that is reveals from their report.
That's not your concern. That's not your concern. What they have done, tender or no tender.
All the
that's
tenders
it.
are with us, madam. We have
No,
everything.
if the legitimate beneficiaries.
Kindly give me some time.
The petitioner in this writ petition filed as a public interest litigation alleges serious irregularity in the implementation of the Pradhan Mantri Awas Yojana within bracket PMAY, housing for all urban scheme. The allegation against the respondent municipality are twofold, or are primarily twofold. Firstly, with regard to unauthorized collection of funds from the beneficiaries under the head development fund, inverted comma. And the second being that such of those beneficiaries who did not pay the development fund, their names were struck off. As early as on November 2022, the Office of the Accountant General within bracket Audit 2 West Bengal had audited the accounts and has pointed out the illegality and held that there is unauthorized collection of 439.42 lakhs towards development fund from HFA beneficiaries. It appears that the said audit report remains intact as on date. It appears that. Apart from that, the State Urban Development Agency has also taken note of the performance audit conducted by the Auditor General of India since the inception of the project in 2015-16. And after noting the relevant paragraphs in the performance audit, has held that the demand made by Dinghata municipality for development cost along with beneficiaries' contribution for construction of DUs impose severe financial burden on the existing economically weaker section beneficiaries, which finally resulted in removal of 187 legitimate beneficiaries. Furthermore, it is stated that one of the beneficiary belonged to SC category was removed from the beneficiaries list despite depositing rupees 40,000 as development cost and beneficiary contribution. That is, no. Furthermore, the and furthermore, the unauthorized collection has not been refunded to the beneficiary even after lapse of 3 years. In the communication addressed to the chairman Dinghata municipality dated 6/2/2023 by the additional secretary, UD and MA department, the following directions have been issued. Page 50, sir, 1, 2, and 3. A reply was directed to be submitted by the Dinghata municipality by 8th of February 2023, which obviously should be a compliance report. It is not clear as to what further action has been taken by the municipality in this regard. Thus, prima facie, we find that the action of the municipality in conducting collecting development costs from the beneficiaries is illegal, apart from the fact that removing the names of the beneficiaries for non-deposit of the development costs is also prima facie illegal. The learned senior advocate appearing for the municipality seeks reasonable time to place their stand in the form of an affidavit. Liberty is granted to the municipality to file such affidavit in which they should show cause as to why action should not be taken against the municipality for such unauthorized collection, and also to show cause as to why the chairman of the municipality, the then chairman of the municipality, as to why action should not be taken against the then chairman of the municipality, or if the present chairman was the chairman at the relevant time, as to why order should not be passed, removing him from the post of the chairman of the municipality. The other respondents are also at liberty to file their affidavit in opposition, including the 12th respondent. Time for compliance of the above direction. 2 weeks.
I have got one
weeks,
submission.
3 weeks from date. Reply if any within 2 weeks there are. Yes.
I've got one. Since it is Pradhan Mantri Awas Yojana, Union of India is the necessary
Yes,
party.
we have given.
The Union of India has not been made a party only.
Whoever is authority you file, sir. That is enough. Next. Serial number 14.
The IEP for the state
ASG is
respondent.
there. ASG is Union of India. That's a matter over.
Lordship, in this matter, I am appearing on behalf of the petitioner and enabling the
Lord, I appear for the Boysora municipality, my lord.
Lord, I am appearing for the petitioner.
We thought sir is appearing for the municipality.
Lord, I am appearing for the municipality, my lord.
Very good.
No, my lord, in short, let me the background of this case.
We want community hall concern.
My lord, may I intervene before Mr. Banerjee takes out the matter, my lord? My lord, this matter may be also tagged with item number 76, in which your lordship was pleased to interfere and pass an order by which an order was passed restricting the municipality from changing the nature and character of the land.
Item 76.
76.
We will club both.
My lord.
Item 76 concerns the same property.
Oh, I see.
And there is some interim order passed in the item 76.
Land in nature character change korona. 76.
But a huge amount of money that was paid by the
Yes,
government.
I know, but we have been, Mr. Banerjee, we have been questioned by the honorable division.
I'm sorry.
So, my lord, we have been unable to, my lord, have the matter either heard either way, my lord.
Please,
Sir, wait, sir. Sir, 1 second. We have said in the meantime, the physical features of the land in question will not be altered. No construction shall put up. So
that is one aspect, my lord. Secondly, my lord, 2017, the judgment was passed by the division bench. Till today, nothing has been done. We need a community hall. Now, which will get the preference? Community hall, children's park. Children parks are there. So many. Now, nowadays, my lord, the unit is very small. They are staying in a two-room flats or something. So, to organize their marriage and other things and to assemble, a community hall is needed. It's very, and 5 crores money was paid to the concerned municipality by the government. I don't know what has happened with the money.
Money still lying. May I assure
Let them file a report. Let them file a report.
No, my lord, may I assure your lordships, my lord, that the money is lying with the municipality, but we are unable to, my lord, because you have mentioned the matter several times. Your lordships, but unfortunately, the matter couldn't be reached before your lordships, by your lordships.
No, in this writ petition, you can file a report.
Yes, we'll file a report. We'll file a report.
This writ petition along with WPAP 542 of 2023, as the matter involves the very same issue. In the meantime, the respondent municipality is directed to file a report in the form of an affidavit, where the prayer sought for in this writ petition. You give a date after 2 weeks.
As you
know. Let the petitioner also inform the petitioner on the other petition that the matter is tagged along with the.
The learned advocate for the petitioner in this writ petition shall inform the learned advocate appearing in WPAP so and so that both matters have been clubbed together. Next.
May I leave, my lord? I'm sorry. I wanted to see in a different place. It is my misfortune, I should say. Very first day I appeared before your lordships.
Yes.
Very first day.
First
And
day.
that was the first case. And it's so unfortunate. Anyway, whatever is done is done. May I leave, my lord?
My lord, only one thing, my lord, may preference be given to the matter after 2 weeks, my lord. Otherwise,
Yes. We'll see that after 2 weeks.
yes, deeply obliged, my lord. Deeply obliged.
Item number 15, my lord, I am for the petitioner, my lord. This is the review service, my lord.
Restore the water body.
My lord. My lord, before making any submission, my lord, I am inviting your lordship, my lord, kindly come to page number 24, my lord, and thereafter page number 34, my lord. My lord, there is a water body of, my lord, approximately 37.4 acres of land, my lord. And this water body has been, my lord, filled up by the private respondents, some of the private respondents, and my lord, I have submitted my representation before the concerned authorities. But most surprisingly, my lord, the authority concerned, the Paniati municipality, my lord, used to dump garbages in the water body, my lord. I have annexed the photographs, my lord.
My lord, your lordship knows, my lord, under section 17, capital A of the England Fisheries Act, my lord. My lord, authority is the executive officer of the municipality.
But see the amount of garbage which has been dumped.
No, my lord, I am appearing on behalf of the Paniati municipality. My lord, this is, my lord, fourth round of litigation, my lord. Initially, my lord, kindly see, my lord, 2 writ petition was filed. One has been disposed of and another is dismissed. My lord, in the course of the writ petition, the Paniati municipality made inspection. If your lordship kindly come to page 5 once. My lord, second paragraph, no illegal filling of water body could be seen. My lord, thereafter, PCB has also inspected the premises. My lord, which is, my lord, page 12. My lord, kindly see page 12, point number 1. Water body named Asharam Jhil was almost fully covered by water and such and such. My lord, there is no indication that the water.
What happened to the matter before the Green Tribunal?
My lord, it is pending, my lord. Affidavit
I am not a
direction has
party
been passed.
before, my lord, Green Tribunal, my lord.
You implead them. We'll give you.
I am appearing on
My lord, this may be fourth or fifth round of litigation, my lord.
Lord, the main kingpin is the respondent number 13. Lord, he is initiating, Lord, the number of the cases on the same cause of action. Lord, before the National Green Tribunal, he is the petitioner.
Which petitioner?
Which petitioner? Respondent number 13, Lord. Sujoy Sarkar.
So he has already approached.
For the many cases. And when, Lord, he has initiated the proceeding before the National Green Tribunal, there, Lord, I appeared and I took a point that the matter is barred by the law of limitation. The moment this point was taken before there, Lord, he has changed the name of the petitioner from Sujoy Chakraborty, Sujoy Sarkar to another, and the another person was projected by the Sujoy Sarkar and filed the present litigation before your lordship.
No, this Sujoy Sarkar is a respondent.
Here he is the respondent, but all the previous litigation, he is the petitioner.
My lord, in earlier writ petition, my lord,
is only to save
in
the
earlier
water
writ
body,
petition, my lord, power of attorney holder is Sujoy.
No personal gain will be received from this litigation, my lord.
After some arguments,
Till date, the nature character has been already changed, my lord, of the water body.
After some arguments, the learned advocate appearing for the petitioner prays for permission to withdraw this writ petition to pursue the remedy before the appropriate forum. Writ petition dismissed as withdrawn with the aforementioned liberty.
Grateful.
Great.
Item number 78 and 79, your lordship, I've mentioned your lordship has directed the matter to be taken up any day, your lordship, in the month of March, your lordship. It was that, your lordship, the 29 crores was to be refunded by one of the parties. Lordship has already.
It is there in the list.
Lordship may very kindly takes it, lordship.
As early as possible.
Grateful, my lord.